how to effectively write a law school exam. So I just wanted to, before I introduce the panelists, I wanted to make a few comments that I think are going to be, that I just wanted to, I think that all of the panelists here sort of want to express to you is that, you know, not only in law school or your master's of law program or whatever you're doing, is it a trying time, you know, because it's near finals. But it's not lost on us that you're doing this online during a time in our nation that is a little bit crazy. So there is a lot of pressure on you. So I just want to take a moment to say that as if law school and law exam pressure was not enough, I'm very cognizant of the fact that learning online is a very different, you know, ball game if you're not already in a law online program. And also just this time that we're in, I've spoken to many of my law students. I know Professor Raposa has, Professor Hale has, and it is just a very anxious time. So one of the big purposes of these free webinars is to essentially just give you information that you need to sort of lighten that load of having to figure out for yourself, you know, what is everything I need. And that's really what we want to do for you today. One of the other really important things I wanted to tell you is that, and I say this to a lot of my students, we can give you a lot of the tools here, and it may make total sense to be like, yeah, that looks good. But if you don't go out and actually specifically implement those tools, it's not going to help you by just listening to us, right? You want to make sure you take what we're giving you and you say, okay, I'm going to do this on my practice, evidence exam, torts exams, property exam. So I just wanted to I wanted to introduce our amazing panelists. So we have Professor Brittany Raposa, who's at Roger Williams. Brittany has put together the amazing PowerPoint as well. She's our PowerPoint queen, and she's also the queen of many, 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 many other things. So Brittany Raposa, and then Professor Melissa Hale, who is at Loyola Law School in Chicago. And so these two ladies are amazing. I think that, you know, one of the things that's going to make this workshop a lot of fun, or this webinar a lot of fun, is that we do have sort of really great panelists who really, really care about their students. So I'm going to, while Professor Hale or Professor Raposa is talking, I'll also try to post some links, although I can't seem to. Hold on one second. Let me just see if I can get the chat. I can't get the chat. I was going to try to post some links while they were chatting. But if I'm not able to, then I will just tell you where certain things are and where you can find them. All right. So I'm going to turn it over to Professor Raposa, who's going to give us sort of an outline and kind of go into what we're going to be talking about today.
Yes.
Yeah, so take it away.
So, I'll take it. I'll try. So today, I think we're solely focusing on number 4, so the execution phase, but I'll quickly just talk about the exam writing process, especially if you attended or watched our last webinar on how to effectively outline and kind of prepare for exams. You should, if you haven't, you should watch that hand in hand with this one, because we talk about kind of steps 1 through 3, maybe steps 1 through 2 really in detail in that webinar. And then we're going to get into 3 and really 4 today.
Those are on our YouTube channel, so LawTutors LLC YouTube channel, which is the How to Effectively Outline webinar. And then just so you know, we have, because of this time, we have an entire free webinar series. And like I said, I'm not able to post the links, but this doesn't stop here. So it continues, right, into next semester or next term. And you can go to lawtutors.net/webinars, or just go to the menu for law students, and you can register for those webinars for free. There's no catch, there's nothing like that. So I just wanted to let you know that those are there available for you. All right, sorry, Brittany.
That's okay. Can you go to the next slide?
Yes, ma'am.
Thank you. And so this is what and this is just kind of a recap of what we talked about at the last webinar, but also if you're new, just to talk about the two other phases. There always comes first, right, the planning phase. So like preparing for your final exams. And what you really want to do is come up with a detailed schedule in order to get you ready for those exams. And the semester, I mean, it's kind of going really fast right now. It's the end is coming and the end is near, which is a good thing, but a stressful thing, I think,
The
for
end
a
is
lot of
near, as Professor Raposa says.
that
If
was
you
probably
take
not the best
anything from this webinar, just take away that the end is near.
Right. Yeah. It's probably not the best phrase to use, but it is. Um, and so it's really good to just make a really good detailed schedule. I always think your outlining should be done by Thanksgiving. So after Thanksgiving, you're working on practicing problems, and you're kind of gearing yourself up to practicing this execution phase that we're talking about, actually writing exams or doing multiple choice questions or whatever have you. Um, but this is kind of just what you definitely want to do after this webinar. If you don't have a plan, I would really schedule it out. When are you going to work on the torts outline or other classes outlines that you're in? And when is your goal to get them done by? And so this is just a suggestion of what can get you prepared, right? So making outlines or writing outlines can definitely get you prepared. Maybe checklists if you're more of a checklist person, like if you are in torts and you need to figure out how to write an answer on negligence, make a negligence checklist, and you can do that for every topic in any subject. A flow chart too, it could be really helpful for that. If you're in con law, for example, flow chart all the steps for the commerce clause or something like that. Um, Sometimes making a rule statement page is very helpful. Just what are the rules that I really need to memorize for this exam? And it's like a memorization sheet that you can make for yourself. Um, any important cases that you think you might need on an exam or to discuss on an exam, you could also just get those ready to be discussed. And honestly, just make sure you're preparing anything that you need help with or that can help you write your exam or take your final exam.
So I just wanted to talk to, some of you know, and I think all of us believe this, when you do your checklists and you do your rule statement page, don't just do the checklist, okay, these are the elements of battery, right? You want to do it in such a way that it's going to actually aid you on the exam. And this is also one of the things that Brittany is talking about. This is going to set you up for also any pre-writing that you want to do. Those of you who have me, you know how big I am about pre-writing as much as you possibly can before the exam. And so these are tools are going to also really help you pre-write, like the rule statements page or even the checklist. They sometimes like to call them essay checklists, right? So they're not just like, okay, this is battery, this is whatever, but how would you actually go about using that information on the exam? So at all times, be very mindful of how you're doing this and say, is this going to help me on my exam, as opposed to just like, okay, so I just make sure I have all the law in there. Professor Hale, do you have anything to add about that?
Yeah, as Professor Shaw is saying, make sure this helps you on your exam. This is where Professor Raposa is kind of going into the practice phase, because as you outline, as you prepare, knowing the type of exam you're going to get and knowing what the hypothetical is going to look like is going to help you reverse engineer that outlining phase so that you're not wasting your time. By the way, I apologize for the weird light.
Her halo.
You're not wasting your time just kind of putting in everything from class, but you're really focused on how is this going to help me in the exam. And I always look at it sort of as this might be a silly example, but like a shopping list. If you have a shopping list that you need to memorize, you want to think about, am I limited on time? And if so, I might want to organize the shopping list based on where things are in the store, right? And that's where the practice phase comes in so that you know what your hypothetical looks like.
Yes, awesome. And then we're gonna, Professor Post is gonna talk about the practice phase, and then when she talks about some of those things, I'll also tell you specific areas that you can find this information.
Yeah, so the practice phase is something that you definitely want to do. It's what a lot of law students skip. So a lot of times law students, when they're studying for exams, that means they're just like reviewing and outlining up until the day of the exam. And that's typically a mistake, right? Because you want your outlines to be finished and you want all of the material to be synthesized and organized a good chunk in advance of your exam so you can practice questions. So you can start to execute applying a lot of facts, really starting to see if you understand this stuff, and also practicing your exam writing. And so you can get this stuff, and I think we talk about it later too. You can get this stuff in a variety of different places. Maybe your professor has prior exam questions that they make available to you or available to students. There are supplements that you can get questions from, like an examples and explanations book or a Q&A book or a Glannon guide. And a lot of times, particularly in COVID, your law schools or your schools will have these supplements available online through their libraries, so check that out. There's also good sample exam questions to write in case books, in the notes section after a case. There's hypotheticals that are posed, which are good exam practice problems. And then I put Kaplan here, but a lot of times companies like Kaplan, Barbary, Themis, they have free resources for law students where you can get some practice questions, and things like that.
Another couple other sources is there is a company called Case Briefs and studybuddypro.com. And what you can do, here's a little trick, is register for the 7-day free trial. And we made it so all the materials are downloadable, sort of. So the mini essays, the outlines, things like that. You can register for the 7-day free trial and use that time with Study Buddy Pro, because what it does is it has the videos on your topic that connects with like mini hypotheticals, that connects with like multiple choice questions on that topic. So everything is interconnected, and it also connects with your case brief. So if you're doing Hadley versus Baxendale and contracts, and you're watching like a little blurb on it, you can get a little sort of educational video, probably from Professor Hale, because she loves contracts, and things like that. So one of the things for some of these subscription-based things is you can do a free trial. All you have to do is just cancel it. And then Professor Raposa made an excellent point about those case notes. I can't tell you how many times Professor has used their actual exam fact pattern based on those little case notes after cases. So that's a great area. And then of course, first and foremost, always is going to be your professor's exams, right? If we're talking about, specifically getting into the head of your professor, those exams and those exam rubrics that they put out, or those essay checklists or sample answers that they put out, those are gold, right? Those are gold. That's the area that you want to focus on the most.
And not just the notes after cases that Tanya mentioned, but some of you that I recognize in the participant list have told me that you have a professor that loves to use the problems in the casebook.
Oh yeah.
And that's even better. That's a great way to use to find a hypo and create a hypo for yourself. And that is something that I have talked about with you guys, but I wanted to share more widely. If you have a professor that loves using those problems and the end of the cases, turn those into hypotheticals and write them out.
Absolutely. Professor Raposa, what are some common final exam study mistakes? I just thought of that question off the top of my head.
I kind of talked about some of these already, right?
But, sorry. Do you want me to go to the next slide?
Oh, no. So not outlining is definitely one of them. And that's just something, these mistakes are something I'm experiencing from being a professor in a law school and talking to students after taking exams and them not getting their the grades that they wanted. And then when we debrief, these are the common things that come up. So not outlining at all. So the student never took the time to sit down with the entire subject and put it together and really pull out the rules that they need to answer an exam question. Um, I alluded to this, outlining up until the day of the exam and not leaving themselves time to practice problems before the test, which can be very difficult. Not reviewing the law, that happens. Like students just kind of think, well, we read all of these cases, but they never actually picked out the black letter law, the law that they need to include in a rule statement to apply to an exam. Um, One really big mistake, and this might be something that's popular. I know with the pandemic, a lot of law schools are kind of shifting to open book or open note exams. And
Mhm.
so, something a lot of students do is they just don't study for it. They think, well, my notes are there. And so they prepare their notes and then that's it. But it's definitely my philosophy that you should prepare for an open note exam as if it was closed. Um,
Absolutely.
so you don't have to spend time sifting through all of that material, and so that way you know it really well, so you're going to apply it correctly. And then of course not practicing. So if you don't practice for an exam before you walk into it, it's like that's your first shot. You got to the exam, that's the first time you're doing something, so you really don't know how you're going to do. You don't even really know, I think, if you understand the material because you've never applied it before. So you don't want the first time to where you have a revelation that you don't really know or understand the law to be at your final exam. You want to know that when you're practicing problems so you can remedy that. Those are the biggest mistakes that I've seen with students in preparing for final exams.
And if you need to practice problems, or in fact, I encourage this, if you want to practice problems in the beginning, open note. That's a great way to get the information solidified in your head too, because you can tell me that battery is an intentional, harmful, or offensive touching, right? But until you're blue in the face, but then it comes on an exam and you're like, oh, how do I apply this exactly? Or you think you know how to apply it. So do those practice problems. If you're like, I'm not ready to test myself, that's fine. It's part of your studying process. And so do those open note with your notes beside you, because remember, your exam is not going to be a recitation of the rules. It's going to be actually applying them. So why not practice in for the exam the way that you're going to be taking the exam? All right. We have some more common essay writing mistakes. This is my favorite part, not because they're mistakes, but because these are things that just happen all the time. And Professor Hale, Professor Raposa, and myself have seen this so many times. And we're not just going to be like, don't do this, don't do this. We understand that this happens a lot, and we also understand why. And so to talk about some of the common essay writing mistakes, I'll just go through some of these, and then Professor Raposa and Professor Hale, please interject at any time. Misreading or not reading the call of the question is going to be one of the biggest issues, right? I mean, I can't tell you how many times professors are just like, why didn't they read? Like, it says not to discuss intent, or please don't discuss assault only battery, that sort of thing. That's going to really annoy your professor, and it's going to lead you down the right track. So make sure, and sometimes it might be good to read that call of the question first, just so you're not looking. It might not be helpful, like if it just says what are the rights of the parties, then you'd be like, okay. But if it's like, please discuss this but do not address this, that's going to be super helpful. Organizing and outlining is a major part that you can do beforehand. And as Professor Raposa was talking about, those essay checklists, those flowcharts, you organize your answer before you get into that exam, right? You organize, what's a battery question going to look like, and how would I talk about it? What's a offer and acceptance, formation, and how am I going to talk about it? being too conclusory is probably one of the biggest things. And I'll let Professor Raposa and Professor Hale talk about this a little bit more. But um, if you are not always asking yourself or answering the question, why, you are probably being too conclusory. Professor Raposa, do you want to go through some of the other ones, and then Professor Hale as well?
Sure. What I see the most, I think, is students who restate facts from the fact pattern. So
Yes.
there's really no analysis there at all. It's just restating what the professor already knows, and because they wrote the question likely or they made the question. And so there's a difference between connecting law and fact together, which students fail to do. They fail to integrate law and fact to actually analyze, and instead they just restate facts. And so when you do that, we read a conclusion, but we really don't have the reasoning as to why you got to that conclusion. So it's really a lack of analysis and just a really heavy emphasis on facts, and we kind of need both integrated with law and facts. So indicating what the legal significance of those facts are that lead you to reach the conclusion that you're going to reach.
You use, oh, sorry.
No, go
Can I
ahead.
just say, you use words such as, if you're like, how do I do that? You use words such as when and here, instead of just saying, John punched Joe. It's when John punched Joe, he committed a harmful or offensive touching. And Professor Hale has, I always use her analogy or what she says about facts and what they're not supposed to do. Professor Hale, I always use this.
So this worked better when this tells you a lot about mine and Tanya's age and when we started teaching. But when I started teaching, people didn't type exams, they handwrote them, and you often had a limited amount of space. You were given a blue book or you were given page limits. And I would say that, the facts are already living rent free on the fact pattern. So if they're going to live also in your blue book, or in your case, in the typed document, they need to work for that. They don't get to live there rent free again. And the biggest mistake I see with that, we're going to talk more about this in further slides, because a lot of exam writing is the analysis and how to do this properly. But the biggest mistake I think I see from students is assuming that something's obvious, right? So when Tanya says, when Bob hit Jim, that was a battery, students kind of look at that as a very obvious thing. Well, like, of course punching someone is harmful. Of course that's a battery. Well, say that. Say that when Bob punched Jim in the face, that was a harmful contact. And it might be obvious to you. And I will bore you later on with tons of stories of students who something seemed very obvious to them, but it wasn't to the rest of us, or vice versa. And just a quick note on the outlining, organizing your response. You can't not do that. But the other reason you want to kind of think through this is to make sure you don't run out of time. I end up dealing with a lot of students in their second semesters who have not done well. And one of the most common mistakes I see is not students who don't know the law or don't know what they're doing, but say there were 2 parts to an essay. Part 1 was perfection.
Yeah.
It was an absolute 100%. That got an A, but then they didn't even get to part 2 barely. And how are they gonna, that doesn't balance, the math doesn't check out. So part of your organizing is thinking, how many questions do I have? How many question parts do I have? And how much time do I have? And can I make sure that I get to everything? And realizing that it doesn't have to be perfect. You have to finish.
Yeah, exactly. And Professor Hale's right. We have so many stories. We might just do a webinar just on our stories, and nobody will come, but it'll still be fun. Professor Raposa.
So yeah, and then a mistake that I see a lot is not using IRAC or like a CRAC, so issue rule analysis conclusion or conclusion rule analysis conclusion. to organize answers. If it's just stream of consciousness on a page and it has no organization, no structure, that becomes very difficult to read. And then I'm a big advocate of headings and subheadings to separate each issue or sub issue. And so when students don't do that, it just adds to the disorganization. And using headings and subheadings makes it more organized.
I have a student talking about student stories who told me, and I know the professor that they're talking about, that the professor was like, yeah, I think your answer was probably good, but I actually just got really frustrated because it wasn't organized. So I literally just stopped. And I was like, ooh. Now, while I personally wouldn't do that, you absolutely can have professors who do that. So make it as easy for them as possible. All righty. The characteristics. This is also my favorite part. Okay, every part's my favorite part. The recycled answer, and this kind of goes back to what we were talking about in terms of restating the facts. It rehashes a lot of information set forth in the fact pattern, but it doesn't cover any new ground, or as Professor Hale would say, they're just hanging out. They are freeloaders. Okay, they're not working. So it can like have whole parts of facts. And then, by the way, students will say, yeah, but if you don't include facts in your analysis, students will be like, yeah, but Professor Shaw, you said not to use the facts. No, don't restate the facts. Use the facts, yes, with connectors, right? When, here, because. Restate the facts, no. The superficial answer, right? The one who just kind of breezes in, makes an appearance, and they're like, thank you, goodbye. It just doesn't give any detailed analysis, and it states conclusions without any depth or information. We all have superficial people in our lives, right? Yeah. You don't have to tell me who. But basically, if they just basically were just like, okay, well, I'm just going to kind of breeze. And one of my students yesterday during office hours said this. He's like, I don't know why I didn't do well. And he did very poorly, and he's very intelligent. And he's like, I mean, I guess the only thing I didn't do is just like didn't put in details. Do you think I would have but why did I do so bad? I'm like, because your entire exam is supposed to be putting in details. You can't just be basically, the personal jurisdiction is this, and then just be like, why do I need details? Because the entire exam is actually details. Professor Hale or Raposa, do you have anything to add about these two? No. Low-hanging fruit.
Yeah, actually, Tanya kept saying the whole exam is details. If you're practicing law, your whole career is details. So
we know it.
Used to that.
I know. How many times I've tried to skate by, sometimes it doesn't work. There are times where I'm just like, I'm so tired of details, but yeah, it is. So if you don't like details, not a good area. Go ahead.
Student has a question. So to
clarify, yes.
So to clarify, do we write as if the reader has no knowledge on the issue, situation, or case?
Yes, with the caveat, right? They know the facts, so you have to assume that your reader absolutely knows the facts. So you don't write as if they don't know what the facts are, okay? But you do write as if they don't know the rule, so you have to state it, and they don't know what the analysis is going to be of the problem. Melissa, do you have a better way of or Professor Hill, do you have a better way of maybe putting it?
So a test that I sometimes do to my students, it's really hard because I usually know the fact pattern if they're my student, but I read their essay and I try to figure out if I can determine the fact pattern. And if I have to go look it up, they're probably not putting in enough details. That doesn't mean that your grader has no idea what's going on. They wrote the fact pattern. But again, we're trying to test your legal analysis and your legal skills. And part of that is, think of going to court. Yes, there's been multiple filings. The parties sort of know the facts, but your job is to literally explain, when this fact happened, that was important because of this rule element. And I like to think of it as a formula. You can be repetitive, but literally like a Mad Libs. when blank fact, that was this element because, or this blank element was met because blank blank this fact. You're tying those things together. So you're not just saying, hey, let me tell you a story about what happened in this fact pattern and let me repeat everything, but you are being very specific as to why you believe certain things and what facts go with what elements. Because I mean, one very short story I promise that we have is I once had a student who English was not her first language, and I tested assault. So I said that a gentleman at a bar was hitting on a woman. I took that to mean flirting, and I was testing a very gray area of assault because he was sort of aggressively flirting. But I kept saying hitting on, which is slang.
Yeah.
And I realized when I read this essay that this poor student, and it made the fact pattern so horrifying, thought that the man was hitting on her as in a battery. And she absolutely understood battery, but she didn't understand American slang. And we're not testing American slang, we're testing torts. So keep that kind of thing in mind, that you don't know if you're going to interpret a fact the same way, if you're going to see the fact the same way. We all bring different backgrounds, different life experiences, even things Tanya knows. When I first moved to Boston, she moved to Boston from California. I moved from Michigan. Sometimes people would be talking about things that were very Bostonian. You know, you have to explain yourself because you don't know the experiences of the person reading it and that they're going to have the same interpretation.
No offense to Professor Raposa, who's still in Massachusetts. We actually wish we were there a lot sometimes too. Jimmy's, Wicked, that they take R's out of words and then they put them in words that they're not supposed to be in. Things like that. All right. Professor Raposa, what's the low-hanging fruit?
So the low-hanging fruit answer is the answer that just addresses really straightforward issues and doesn't do a deep dive into the fact pattern, doesn't discuss the issues that are a little bit more gray, only discusses the obvious issues. And it's really the student who maybe doesn't have a really solidified understanding of the law enough to do a deep dive into the essays, but it becomes then a student who's really not getting a lot of the points that their professor is looking for because all of the issues are not going discussed. Right. Then there's the archaeological dig, which I find a lot of. It's the really hard to understand answer. It's so disorganized. The answer is somewhere in there, but it's really hard to pull out. It's not written in an IRAC or CRAC structure. It's really just kind of the student stream of consciousness all over a page. Really difficult to understand. And then there's the rooters, which stands for run out of timers. Those are the students, I think. Yeah, I think Professor Hale was talking about it earlier. They get to some of the answer, but not all of it. So that's like a time management issue. Typically also signals you didn't do enough practice questions, so you didn't anticipate how long something will take. And so we can only grade you, right, for what's on the page. Even if answer 1 was so good, we can't assume answer 2 would be 2, so you get an A. And so that is where time management and practice really comes into place.
Yeah, absolutely. All right, so now let's get down into some of the nitty gritty. Okay, so issue spotting in fact patterns. Which facts trigger issues? This is super important because I know a lot of times we're like, just spot the issues. And you're like, okay, I don't know how to do that. So that's not helpful. And we totally get it. Like people are just like, oh, all you do is issue spot. And then you go and you're like, okay, well, what am I supposed to do if I can't spot them or I don't spot them all? So here's some helpful tips on how to spot the issue and spot the issues. Peoples and parties are always going to be really important, right? Because it's also always someone suing someone, or the state, prosecuting someone. So the peoples and the parties are a big deal. Dollar amounts and numbers. We understand that you did not go to law school to do math, but these are going to be important, especially if we're thinking about in the context of damages, right? Which is always something that we have to talk about, damages in contracts, right? Particularly, are we talking about expectation, restitution, reliance, consequential? You're not going to have to do some crazy math, but you're going to have to know the basics. Details about people, places, and things. People, places, and things. Big deal. All right. Actions that the people take. Actions that the people take are going to be really important because that is going to all be the basis of probably a claim, right? Is it a battery? Is it an assault? Is it one of those things? Belief or state of mind, that really comes into play, right? When things where we take into account intent, for example, if you're in criminal law, if you're in torts, is this negligence? Is this an intentional tort? Is this strict liability? Criminal law, what does the mens rea have to be? Specific intent, general intent, and reasons for acting or not acting. Great example is, in torts, was there a duty to act? Or in the sense, a duty to not act, or is not acting somehow breaching a duty, the failure to act, or in evidence, is silence considered an admission? In criminal law, all those things, these particular parts in a fact pattern are really going to help trigger you. Professor Hale or Raposa, do you have anything to add on this?
I like to remind my students that I'm not a creative person. I think I am. I like to think I am, but I am not a creative writer. And so your fact patterns, your professors are not writing these to create three-dimensional characters with, character arcs and depth. So if they're giving you a fact, it's in there for a reason. And that doesn't mean every tiny little fact has to have a purpose, because sometimes you just need them to kind of make the hypothetical make sense. But for the most part, if the professor's telling you that someone is a certain age or has a relationship to somebody, or any of these things that are listed here, they're there for a reason. So don't just kind of dismiss them. Ask yourself, well, what issue, what area of law might this trigger? Why are they telling me this fact?
Yeah, I think that's important. One of the only things that I would do a caveat on this for is sometimes professors just like to, do a long introduction about certain things that may not be relevant, but you'll know that, right? Like on a contracts exam I was reviewing, it was just sort of about, how, Johnny liked to play baseball with his father because ever since they were young, blah, 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 and all this sort of stuff. So so they like to do that. We're human, some of us. And so we sometimes just like to, pontificate a little bit. But another reason why this is really important, and I can't stress this enough, your professors sometimes really spend weeks creating these exams. Like, it's a labor of love. It all comes down to their exam. So you also don't want to insult them by missing these things. And I know that sounds really a strange thing to say, but they're like, but oh my God, I put this in and I spent a week thinking about it and blah, blah, blah. So remember, it's like a labor of love for them. And again, they've waited the entire semester for this moment. I know it's your big moment, but it's also their big moment. So you don't want to miss the details of these particular things. And I know it's hard to be like, okay, I don't know what I'm supposed to look for, but hopefully this sort of list here can help you say, okay, this is there for a reason. They are doing this or not doing this for a reason. All right, because Professor Raposa loves headings. I mean, we all do. I'm gonna let her talk about this a little bit.
Yeah, so this is the formula. Part one is heading. So using headings is always the first step to separate your issues. And then I typically recommend starting with an issue statement or a conclusion, and that of course is also going to depend on your professor's preference. Then a rule statement, then an analysis, and then a conclusion at the end. And so I'll talk about headings and I think why they're important. So one thing I think is that they just make your essay a lot organized. So you're just talking about one issue under one heading. You're not muddling issues together, which is really what you don't want to do. That results in the essay that's really hard to understand what you're saying. So as a rule of thumb, I typically say if you're going to interject a new issue or you're going to interject a new rule, put it under a new heading. Also, it kind of prevents what actually, so Tanya already talked about in terms of a professor who just doesn't want to do that work. And if you don't organize it for them, then they're probably going to stop reading it. And so if you make the grader's life a lot easier, then you're going to likely get a better grade. So that's something to definitely consider. And also it's my opinion, and you know, this is definitely a shout out to another professor that I work with who's our writing specialist. You know, clean writing is clean thinking and clear writing is clear thinking. So if you separate your headings out from one of each other and you're more organized, your thought process will be a lot more organized and you'll just end up developing a better answer.
Yes, perfect. And this is also to make it easy on you, not hard, right? Everything we're doing here is not like, oh my God, I have to do all this stuff. This will make the process so much easier on you, because there's just so much stuff that goes into an exam, so much law, so many things going on, that it'll just make it so much easier for you in terms of execution. Why are headings important, Professor Raposa?
Oh, so I kind of talked about this already. Sorry, I got a slide ahead.
That's all right. I know you did, but I was like, maybe she has more to say because there's another slide on it.
Yeah, no, I guess I just like it that much. It's just heavy emphasis.
She does, because look at we have sample headings.
Yeah, and these are just sample headings. Like if you're taught in property and you're talking about a conveyance, the heading can be land sale conveyance. If it's an issue of whether someone has a tenancy in common or a joint tenancy, that could be your heading. It just conveys the issue that you're discussing. Negligence, products liability, you know, I think as long as it conveys or signals to the reader the issue you're going to discuss, then it will be a good heading or subheading.
So Professor Raposa has said that it should convey the issue, but if you notice, her sample headings are not the issue statement.
Yes.
They are short and clean, and they are not an entire sentence.
Speaking of the issue statement. Sorry, these things are very exciting to me. The issue statements should direct the reader to the precise legal issue the question is going to address. Now, before I go more into this, some of you who I know, and I know who your professors are, want their issue statements in a very particular way, okay? So we are addressing, but if your professor doesn't specify how they want it, right, we're addressing the best way to address it. But I know some of your professors, and they really want you to do it a certain way, exactly how they want it, and you do not deviate from that. So remember, you always listen to your professor's idiosyncrasies, but this is the way to do it if your professor hasn't already specified how they want it. So the more specific the issue statement, the stronger. Absolutely. If you just say, and we're going to get to this example in a second, and then, and the issue is whether the defendant was negligent, doesn't bring us in to the fact pattern at all, right? That's maybe on your essay checklist, right? Because you don't have facts to tie in, but the issue is whether the landowner owed a duty to the woman that can make him liable in negligence. Okay, now we're bringing in the fact pattern. You're telling your professor, I'm paying attention to this magnificent fact pattern that you created for me, And I'm using the facts in my issue statement. And this is going to be much better than this. Now, when you're doing your essay checklist, sure, we don't have any information. So it's going to be defendant and it's going to be negligence. But when we are transmitting our essay checklist to our issue in an exam, we want to use our facts. Do either of you have anything to add on that? No. All right. Beginning with the conclusion, and I know Professor Hale and Professor Raposa, and I know that all professors sort of want different ways of doing with it. Professor Hale, Professor Raposa, do you want to talk about sort of how beginning with the conclusion is essentially the same as sort of beginning with an issue statement? That's just a different way of doing it. Professor Hale?
I mean, it's the same. You're just reversing the way you're phrasing it. I personally encourage my students to begin with an issue statement because I find if they begin with a conclusion, they only talk about things that support that conclusion and they ignore facts or counter arguments that don't support that conclusion. And going back to what Professor Raposa has told you about kind of details and stuff like that, that gets left out. But that's not the same for everybody. And a conclusion is just as fine. It really is the same thing. If the issue you're tackling with is battery, it's the difference between is there a battery and yes, there was a battery, right? And you have to figure out what works for you as well as what works for your professor. Because just like I have a preference for issue statements because I think it leads to a better analysis, there are plenty of professors out there, plenty, that prefer a conclusion to start off with. So you want to pay attention to that a little bit too. But if you do use a conclusion, you want to make sure that it doesn't sort of back you into a corner of not discussing potential counter arguments or facts that don't line up with that conclusion.
Exactly. And remember, again, it's going to go to what your professor, if your professor specified they want it a certain way, then you do it that way. Writing rule statements, you know, this is really where pre-writing can come in. But remember, the pre-writing part is going to sort of address every part of a rule statement. But sometimes we want to be a little discerning when we're actually putting our rule statement. And one of the things that we always do is we go from broad to narrow. Just remember that, broad to narrow. Professor Raposa, Professor Hale, do you want to talk a little bit about some of the different ways that you've seen students use rule statements, or some of the ways that they can use rule statements on the exam?
Sure. I think that what I do see a lot of is just kind of students writing everything under the kitchen sink with no kind of rhyme or reason, no structure. And so that's why I always teach writing rule statements almost like a funnel, writing the general rule and then keep getting more specific. And so stating what the general rule is, for example, negligence is duty, breach, causation, and damages. And then you continue to get it more specific by defining anything in the general rule. So maybe you define what a duty is. And then if there's any exception to that rule in that definition, then you would include it there. So it just keeps getting more specific as you go.
And Professor Raposa brings up a really good point. Some students will put everything in there. But I also see the opposite extreme, right? They'll look at a problem and they'll be like, okay, I really just have to talk about causation. So then they'll be like, all right, well, there was proximate cause and because it was foreseeable and blah, blah, blah. And you're like, whoa, 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 whoa. Even though the issue, the issue that you have to talk about most might be proximate cause, you want to at least make sure you put the whole rule in there. But on the flip side, as Professor Raposa was saying, is that if that is one of the major issues, right, you don't want to just like talk a ton about the entire rule. You want to, as Professor was saying, exactly general rule and then narrow in on the particulars of your fact pattern.
Can I give my dinner party example?
You can always give your examples because somehow all the interesting things happen to you.
So, well, no, so this is, I cannot take credit for this. This is a former colleague of mine, something he tells his students, and I think it's brilliant. You're setting the table. Your rule statement sets the table for your analysis. What I mean by that is if you were having me over for dinner and you put out a soup spoon, I am expecting soup. I'm excited. It's starting to become winter time. I'm like, this might be some great soup. There's a soup spoon. I'm going to get some soup. But then you never give me soup. And I'm like, huh, I was really looking forward to that soup. Similarly, if you serve me soup, but you don't give me a soup spoon, I mean, we're having a nice dinner party. I'm not gonna, I mean, I might pick it up and slurp, but I'm assuming that we're having a nice dinner party and that's not the appropriate way to eat. I need a soup spoon. So basically, your general rule to the exceptions, I kind of look at it as a reverse triangle. I like Brittany's funnel example. Um, we, when you decide what to put in that funnel, think about what you're going to serve in your analysis. If you talk about something, you need the rule. If you don't talk about it, you don't need the rule. You always need the general rule, right? But when you're thinking about, do I put in all the exceptions? You know, if you're talking about offer, you need to define offer. But you don't need to tell the reader everything about offer unless you're going to make it part of the analysis.
We have a question, and this is a great question. Can the general rule be reworded in our own words, or can it be exactly as it is written on the law? And so I'll give my take on this, but I think Professor Hale, do you want to answer that?
I was just going to say it depends. That's my lawyerly
Yes.
answer. It depends. And then I'll let Tanya explain that.
It absolutely does depend. So this is where practice is super important, right? You don't want the first time that you're rewording something to be on that exam, right? But if you want to reword something in a way that you understand it, there are a couple things that we have to take into consideration. Number one, yes, you can reword it, but make sure that you are not rewording it such that an element or a factor is changed, right? So you don't want to do it so an element or factor is changed or taken out or added, okay? So you can say, negligence is duty, breach, causation, damages, and that's the easiest way for you to do it, right? And whereas some people will have a much more long, negligence is when a duty is owed from the defendant to the plaintiff. They breach that duty. The causation is both proximate and actual. Like, you might be like, oh my God, you have to write it all out like that. Not necessarily. But as long as you don't change or take away a factor or an element. And another thing, the ands and the ors that are in there, do not mess with those. Okay, there are no rewording of ands and ors. All right, don't be messing with the ands and the ors, because those are so important. If it's elemental, then it's ands, right? If it's factors, a lot of times we say, okay, it can be a culmination. It doesn't have to be all of these things. It can be some of these things, but don't mess with those. They get mad. All right. Anyone have anything to add? All right. So, example. In order to be successful in a negligence action, a plaintiff must prove, speaking of negligence, duty, breach, causation, and damages. A defendant owes a duty to any foreseeable plaintiff. A foreseeable plaintiff is one who is considered within the zone of danger as a consequence of the defendant's action. So this is good. Here, we have a situation where we have the umbrella rule, and then we're sort of narrowing it a little bit. All right, and why, Professor Raposa, did you particularly narrow it by talking about the foreseeable plaintiff?
I think it's that signals to me that the call of the question or the issue was about whether there specifically was a duty and whether someone was a foreseeable plaintiff.
Right, absolutely. And another thing is this goes into exactly, this explains to us a little bit further that, this is really where the negligence part comes in. That's what we care about. It's not, you know, we hear people yelling out wrong legal stuff all the time, but it's like, you were negligent. And you're like, yeah, but to whom and how and like what, you know, like to me, to somebody else. So this really like focuses us and focuses you on who you're going to be talking about and whether or not this person was in fact foreseeable, or what we call in the zone of danger. Yes, Professor Hale. Sorry, let me go back.
I think just because Tanya said something that was brilliant, and I don't even know if she knew she said a brilliant thing, but she said it focuses you. And one of the biggest things that I see, especially my newer law students doing, is what I do calling like the brain dump. It's like, let me tell you everything I know about this subject to prove that I was listening in class. I'm just gonna like dump it all. And that's not proving that you know which rule goes with particular fact pattern in the issue you're dealing with. So Tanya mentions like this helps you focus. And I think that's a great thing. Like she kind of said that very quickly. And I just want to highlight that your rule statements can help you focus on what you need to talk about, so you're not going all over the place and sort of losing the crux of what you really need to be addressing.
Yeah, absolutely. Thank you. Shut up, Professor Hale. But you know, it's true, and I don't think that I used to actually talk about that a lot, because I would talk. It was sort of, we would always talk about, or sometimes you're hearing from your professor, like the obligation of what the law student needs to do in terms of, you know, you're just having to work extra hard. But remember, this is actually so that you're not working harder than you need to work, right? And so I think that's really the way I want you to think about this. Not like, oh my God, now we have to do all this stuff and how am I going to remember it? No, everything here is so that you don't have to work as hard. Oh gosh, we spend a couple days on this. I don't know how many you guys have, but the analysis. So let's talk about this. So because is your best friend, right? Because is a fantastic connector. And that is such a great word. When and here are also really good words, but because is like this ultimate connector. So how you set up your rule statement will drive how you set up your analysis. So as we were talking, as Professor Hale was just talking about it, this is going to help focus you on what it is you're going to be talking about. So how you set up your rule statement drives how you would set up your analysis. And you want to work from how you talk about that rule to guide your application. And this is really interesting. And Professor Hale and Professor Raposa and I know this, and we're working on a book. And one of the interesting comments that we keep making when we're using student sample essays is they'll put a rule, and then they'll apply something, and we're like, wait, how did that connect to the rule? Like they didn't define that part. Like I'm confused. And so you want to make sure that your analysis is connected directly to your rule. And don't be talking about something that is totally different from your rule, right? And I had a student, for example, let's use evidence as an example, talk about the rule of character evidence, the umbrella rule that, you know, normally the defendant cannot introduce, or sorry, normally the prosecution cannot bring in evidence of the defendant's character to prove conformity therewith. And then they went right into like, in their analysis, talking about like modus operandi. I was like, whoa, let's take a step back. You need to define the rule and then talk about how in your rule, however, the prosecution may bring in elements that are look like characters or seem like characters, but they're actually to prove something other than character. That's the part of the rule that they had missed. So when they started talking about modus operandi as an exception, as some professors call it, as an exception to the character rule, that wasn't in their rule, right? So I think that's really important. The game of match, right? Match up each element or factor you've identified in the rule by using the word because to make that connection, right? Not Joe hit, John, right? Because Joe hit John, he committed a battery, something to that effect, right? This makes sure, this is the plus factor. This process ensures that you write the facts plus the significance of those facts. So I can't emphasize this enough, and I'm really glad that Professor Raposa stated it this way, because it's not just the facts, it's like, why do we care about the facts, right? Facts matter. And so that's what we want to put in there, is like, why do we even care about this? If you can tell me something, but you're just sort of like, okay, what, so what? Like, I understand that's a fact, but why do they matter? Do either Professor Raposa or Professor Hale have anything to add about this part of it?
A good visual memory. I forgot to do this for Professor Raposa, and I'm sorry. But when I do things for my students and make them a visual in IRAC, for the because, I put in Dorothy's shoes on the Yellow Brick Road. Because I want it in your head because, and I can't sing, so I won't do that to you. But it seems silly, but if you just have that visual of like, because, that's what you need to write. And again, this goes back to what I said earlier, even if something seems obvious, right? You're like, well, of course that was a harmful touching. Don't assume that everybody is viewing that fact the same way. Explain your reasoning.
Yes.
You can also, if you're so inclined, I mentioned setting up Mad Libs, like,
I love Mad Libs. I love writing Mad Libs.
Fact, yeah. Tanya makes like legal Mad Libs all the time. Have fun with it. Create your own like exam template Mad Libs. I have a colleague who makes all of her students, and they can use this on the exam. And yep, I think I'm getting a slide ahead, aren't I? Yep. She makes all of her students for her Civ Pro exam create templates that they can use on the exam, which are basically Mad Libs. Like, the issue is whether blank had personal jurisdiction over defendant blank. The rule is, and like it's a Mad Lib. And then if you're math inclined, this is a good formula. But also think of all that rule you put up when Tanya was talking about the rule statements and the funnel. You want to take the rule element and make sure that you've addressed each part in your analysis. So there's a lot of math kind of making sure that everything is matching.
Absolutely. This is, and don't get scared if you don't like math. Formulas are good, even for the non-mathematically inclined, right? And so application equals rule plus fact. And this is a perfect way of saying it. All right, what does rule plus fact mean? And I understand a lot of you know this conceptually, right? I don't think there's a single one of you or any of my students who don't know the application equals rule plus fact. But the question is, what's rule plus fact mean? And the plus is the because. It is the because. And so this is a brilliant Professor Raposa. And this is why I know why she's been voted Professor of the Year 2 years in a row. Sorry, I had to just do that little plug for her. And so this is exactly the thing that is going to connect the two. So you have an actual connector to use, right? Just how we were saying, like, we understand when people are just like, spot the issues, and you're like, okay. And I've talked to a lot of you about this. You're less inclined to also ask for help if you feel like, okay, I don't even know how to spot the issues, there's something wrong with me, right? And so we want to give you those tools to say, what does it actually mean to spot the issues? What does it actually mean to have a rule plus a fact? Because we understand that this is a different language. So we cannot just assume that you know that language innately. And sometimes your professors do assume that, because I think they've been doing it for so long. And I think that's one of the disconnects, right? Is that there's this sort of assumption, like, don't you know what applying the rule to the facts mean? Don't you know what spotting an issue means? There's this sort of assumption. And I think that one of the things that we want to do is bridge that gap between assuming that you know what this is, and bridge that gap, and then actually knowing what it is. Mixing law and fact together. Okay, So this is a really sort of good thing to do if you feel like you are comfortable with the IRAC and the CRAC method. And correct me if I'm wrong, Professor Hill or Professor Raposa, a student can start doing this once they really feel comfortable with that IRAC or that CRAC, when they're integrating the two of them and mixing the two of them together. Because this is IRAC and CRAC, right? It's just not like, it's not, the rule is not separated out from the analysis.
Yeah, and I would say only do this if there's not a lot to discuss. So all elements are not created equal. If you're dealing with negligence and the duty and breach are very obvious and there aren't a lot of facts to discuss, but causation is the main issue you want to discuss, you can probably do this with duty and breach, but not causation. So you're sort of picking where you do this. It's a shorthand to kind of say, I need to address and kind of check off this element, but it's not that important.
Right, absolutely. And this you would also do in your regular analysis, but if you're also going to be like saying, I have to just talk about certain elements quickly that aren't going to require as much analysis, you might just need a mixed law and fact in there. Abby has a good claim for assault against Danny because by shouting that saw blade is going to hit you while triggering the loud saw noise, Danny created an immediate apprehension of a harmful touching. That is a perfect analysis right there, right? And look at how I mean, you just don't even need that much. It's just connecting the fact and explaining to why it's significant to us. The plaintiff in this case cannot prove actual causation under the but-for test because the damage to the gymnasium would have happened anyway, even if the defendant had not been intoxicated. Exactly. You're basically what you're telling the reader in that situation is, listen, I know that there's this but-for test for causation, right? I know that this gymnasium, something happened, this damage to the gymnasium. However, I'm going to explain to you why it doesn't need it. And that's exactly, I'm going to explain to you the significance of it. So remember, you can also prove the lack of something in a rule. Just, it's exactly the same as proving an element in the rule is disproving an element in the rule. And then the UCC statute of frauds requires writing evidencing a sale of goods contract for $500 or more. Therefore, the oral contract to sell the painting for $11,000 is not enforceable. So these are really good examples of quick ways to analyze, and we much rather give you these short examples because sometimes going through an entire essay and going through every single one can get onerous. But this is exactly how you want to practice writing your sentences. This is exactly. It may not be that this is enough of an analysis for assault because you might have to talk about other things, but this is an analysis of what apprehension is. And that's key. And so as long as you know how to write your sentences like this, your professor will be so happy. I just want to point one more thing out because this example triggered an example for me. Let's say on an exam for contracts, you do see a sale of a painting. So Professor Raposa is selling me a painting for $11,000, and then it's the sale of goods for $500 or more. And all of a sudden, you start that paragraph off as the statute of frauds requires a writing. And I'm using this in a bigger context. And you start talking about the statute of frauds. Now, remember, in a bigger context, you're always going to want to lay out where you are and what we're talking about, right? So if you would never want to start your essay like this, if the professor's like, what are the rights of the parties? You would start with offer, acceptance, consideration, defenses to contract, and then go into statute of frauds, right? So that's another mistake that I see students use. And I know we talked about this before, but sometimes we're so in a rush to get to like, oh, I know this. I know that goods have to be in, sorry, a contract has to be in writing if the sale of goods are over $500. I'm going to talk about that right away. Well, no, because if your professor wants you to establish how we got there, you need to establish how we got there first, and then talk about that main issue. These are just examples of how we analyze issues. Essay organization. Do either of you want to talk about essay organization? Because, I could just talk all day.
Yeah, I can.
Yeah.
We alluded to how important organization is, but I mean, you could have all of the right issues, but have a completely disorganized essay, and another student can have a really organized essay and miss a couple of issues, and they will do better than you. So organization is factored in with grading, whether the professor is doing it intentionally or, to be honest, unintentionally. I mean, I think there's a bias that happens in grading where organized writing just seems better than disorganized writing, so that student then will get a better grade. So organization is really important, and it shows also that you can communicate what you're looking to communicate effectively, directly, and that's exactly what you need to do in the practice of law. So I always say to outline your response very briefly, a sketch of your answer before you write it. And a lot of law students say, well, I'm not going to do that because I have a limited amount of time already and I can't spend time organizing or writing an outline prior to actually writing the exam. But at the end of the day, that 5 minutes that you maybe take to just sketch out an outline, that's going to probably get you a better grade than if you didn't do it. And when I say to sketch out an outline, I mean just like really just what you're going to talk about and when. So just little like bullets of, okay, first I'm going to talk about negligence. And this is what I'm going to talk about under negligence, each part. Then I'm going to talk about strict liability. And then here's what I'll talk about with strict liability specifically. And then you just write your answer under each part that you organized for yourself. And you want to stick to the outline and use it and just kind of fill in the IRAC right under that nice outline.
Yep, perfect. Thank you. Outlining the answer. Professor Raposa touched on this, but and we always say this, and you tell us you don't have time to outline, and we're going to tell you don't have time not to outline. Professor Hale, do you have anything to add about that? Professor Raposa?
No, except Professor Raposa mentioned something about, organized writing and that bias we have. You're learning to write as a professional. Some of you have already learned to write as a professional in a different field, but this is professional legal writing, and it's just an exam, and it might be a timed exam, so we don't expect, professional citations or anything like that, obviously. But in terms of organization, we are looking to see if you are organizing in a professional way. And I don't say that to put more pressure, but just to kind of give you the reasoning of why professors expect it or might have that bias. Remember, Tanya had mentioned the archaeological dig in the beginning. Some of that bias that Brittany mentioned comes from the fact that we're reading like 100 exams. And if you're like, okay, I think they mentioned duty in here somewhere, you're not really inclined to give a lot of points versus someone who has organized it in a very neat, easy to find fashion, right? And this makes the job easier for you. I would just start organizing on the paper that you're going to turn in, on the document you're going to turn in, and flesh it out as you go.
Yeah, absolutely. Absolutely, 100%. And again, I cannot stress enough that you don't have time not to outline. You don't have time not to outline. Later on when you take the bar exam, I know that's not here, there's one part of the bar exam where you actually spend half of your time allotted to outline, to organize and outline, and half of your time. So you're given 90 minutes and you actually spend half of your time outlining and organizing and half of your time writing. Because all that stuff behind the scenes is going to set you up for a fantastic performance. Stacking your IRACs is not the same as stacking the courts, but close. So here, when we're stacking our, not even close, when we're stacking our IRAC, the issue is whether the defendant was negligent when he failed to repair his broken fence. All right, and then, and I can't even tell you how important this is. Stacking your IRAC is like this umbrella and the mini IRACs. I remember once I was talking to my students and it was like, okay, I get it, it was just the IRAC, and so I IRAC'd, and I was like, oh, you think it's just one IRAC for the entire rule, and it's not, right? There are mini IRACs and there are sub IRACs and sub IRACs, and I'm telling you, when you get this down, the fact that each element has its own IRAC, you're going to be like, oh my God, life is so much easier. So that is what stacking. Go ahead.
I was just saying, sorry, go ahead. I was just going to say it makes it easier for you.
It makes it easier for you. It absolutely makes this easier for you, because I absolutely remember it. I wrote this memo for my students, and I think some of you who are on this attending here remember this. And it's literally called, "It's Not One Big IRAC." Because I remember it was sort of like, wait a second, you weren't really shown or taught, like you were told to IRAC, but nobody actually was like, you're like, okay, and so like this entire essay was like one big IRAC. And I was like, oh, okay. And I realized that you hadn't been explained what IRAC actually meant in terms of actually applying the IRAC, right? And so this is exactly what we mean by stacking the IRAC, which is if negligence has these, this is our umbrella rule, okay? Umbrella rule. You have an umbrella issue and an umbrella rule. Those are going to be your overarching issue, whether the defendant was negligent when he failed to repair the broken fence. And you're going to have your umbrella, top of the funnel rule. But each element that must be proven has their own little mini IRACs, right? Duty has its own mini IRAC, breach, because remember in law school, you're actually learning these throughout law school as their own like law almost. And then you're like, oh wait, they all come together. So that is how you want to talk about it, right, on your exam. Because in law school, you're learning each of them through a series of cases and their own rules and their own analysis as to whether or not somebody has a duty. Then you go on and so forth. And so each of these are going to have its own mini IRAC. It doesn't mean all mini IRACs are created equal, okay? It doesn't mean that all mini IRACs are created equal. If something is predominantly about breach, and you know that ahead of time, why? Because you outlined, and you planned, then you don't not talk about these things. They just might be a little bit shorter than your breach. You're not gonna forget about any of these things, right? They just need to be a little bit shorter. And we gave examples on what those shorter analysis may look like. But you still do IRAC each and every element. Professor Hale?
So I love the stacking IRACs because of everything that Professor Shah just said, but also because this really ensures that you don't skip elements, which I often see students do. They're like, well, I thought the whole issue was breach, so I never talked about duty or damages. Well, you still need to. And this helps you kind of create that checklist for yourself. And as Professor Shah said, not everything's created equally. So you might notice that breach is the main issue and that duty and damages are really obvious. And you might not need a full sub IRAC on that. You might do the mixing like she showed you in the other slide. And that's a good way to kind of go through your checklist. Also, in these elemental classes, torts, criminal law, this becomes really obvious, but you still need to do this in things like contracts and things like property that are not always as easy to break down into elements, but they still have their sub issues. So for example, in contracts, and if I'm getting ahead of anybody, I'm sorry, because I don't know where every individual person is in their contracts class, or if you're taking contracts this semester, but there's a concept called excuse. And one part of those excuses is called impossibility. And impossibility requires that the contract be impossible, absolutely impossible, for anyone to be performed, and that there has to be an unforeseen event. So there has to be unforeseen event and then that impossibility. So even though it doesn't feel as elemental as negligence, you still have those two elements, their own sub-IRACs. The first sub-IRAC being, is there an unforeseen event? Why or why not? And then the second part of that stacked IRAC being, is it actually impossible for anyone to perform? So don't lose sight of this in those classes that aren't just as obviously elemental.
Yeah, absolutely. Absolutely. That goes for things like con law too, right? Where it's not so much elemental, but you can still do the funnel, right? Equal protection, the 14th Amendment guarantees that all persons are treated equally, right? What does that mean? What classifications actually fall within the equal protection clause that are protected classes? Okay, so we find a protected class. Then was it an intentional discrimination or was it an intentional discrimination or discrimination on its face? And then, okay, what scrutiny do we use? Do we use strict scrutiny? Okay, is it narrowly tailored to a compelling government interest? What do each of those what do each of those entail? And then we conclude. So even though that's not elemental, because constitutional law is not elemental, right? It's all about our cases. It's all about applying and distinguishing cases. We can still break that down into a way that we're like, okay, I know how to discuss equal protection. Professor Raposa, did you have anything to add?
No, I think everyone said everything that I would have. The one thing I would just stress is that, and maybe it's because this is how I grade, but I think that students who write like this will score better than students who don't. Because, say, for example, you just bundled in altogether duty, breach, causation, and damages into one large paragraph. Some of your ideas might have went missing, but also you might not just have analyzed each thoroughly because you're just thinking of them together and not separate. So
Yeah.
I think the best way to score points on an exam and to just understand the issues better, but at the end of the day, right, we all want to score a lot of points on an exam, it is to write in this way.
Absolutely. One of my students yesterday, I was meeting with him, he's such a great writer, and he has been doing well on his exams. And so I'm like, okay, let's look at the exams. And that's what it is. It's a big bundle. And I'm like, it's really unfortunate because you actually really know this law well. And I think as both of you had mentioned before, you could actually know the law better than your colleague, or even write about the law more beautifully than your colleague and still score lower, simply because of the way that it is organized and laid out. Avoid dwelling on what's obvious. Yes, we don't want to dwell. Professor Raposa.
Yeah, so I think we talked about this a little bit before, and all of these ideas kind of mesh together, but timing is like definitely an issue. I can't tell you how many students I've talked to where they did okay, but they just ran out of time. And so you really have to plan your time accordingly on an exam. And if something is really obvious, don't spend a really long time talking about it. A really good example of that is like civil procedure and diversity of citizenship jurisdiction and the amount in controversy. The fact pattern tells you that they're suing for $100,000. You do not need to spend a significant paragraph talking about how the amount in controversy is over $75,000. It's an obvious issue. It can be dismissed quite quickly with a couple of because statements or a couple of analysis sentences and then move on. Because then you've got that point. Now let's spend a lot of time getting other points. So you have to use your judgment and exercise your judgment. But you really know if you have to talk a lot about something if it's a gray area. It's not black and white. it's muddled. You can see both sides of an argument. That is where you want to spend your time, not on the clear, more obvious issues.
Ah, perfect. I couldn't have said it better myself. Absolutely, 100%. This is kind of what we sometimes call weighing our issues, and that is which ones do we know are going to have more weight than others, which does not mean we don't ignore those.
And I want to be very clear. We said earlier that you have to explain things that seem obvious to you. So this does not mean you skip the obvious or you don't address it at all. We're just saying that if the fact pattern tells you that there's a amount in damages or that there's a contract or that someone acted intentionally, you don't need an entire page written about that. You touch on it and move on. Also, what Professor Shaw mentioned about you weigh your issues and you make that judgment call. I get so many students come to me and they're so frustrated that I can't give them a always talk about this or never talk about this, or, you know, kind of like almost like a checklist to use. But that's what you're learning in law school. Imagine if the three of us came to you, you're our attorney, we're telling you about a problem we have, and we tell you the three of us have a contract. And we tell you that and we show you the contract. And then you bill us maybe 5 hours on a memo that addresses why we had a contract. And the three of us are going to be like, no, but we told you we had a contract. That's not our issue. That's kind of what you're doing in these exams, right? You're exercising that lawyerly judgment of where am I spending my time?
Yes, because it's always the gray area. And I know people get annoyed when lawyers say it depends, but we sometimes would be committing malpractice if we didn't say it depends, right? Because then when we're like, it depends, well, let's go look that up or research it or whatever. So that's exactly what it is, because that's who we are. We don't dismiss things, right? Like if our client didn't have a contract to begin with, then we're not going to talk about whether or not there was a breach of that contract, right? But if it's kind of obvious that there's already a contract, we're going to talk about offer acceptance consideration, quickly establish that it's there, or if the fact pattern says they entered into a valid contract, or your professor says, please do not discuss formation, then that. So remember, we don't ignore them, but we have to know where to, and that takes practice, in case we haven't emphasized that enough. Extra tips. All right. Some professors require you to do this, and without doing it, it is not a complete analysis. Okay? It is not a complete analysis. All right, and that's very important. So within that within that A, remember, argument, counter argument, conclusion. And you begin with the argument that you're going to ultimately conclude about, right? John owed a duty, a special duty to Patricia because, you know, they were married. Patricia's gonna, you know, argue, John's gonna argue that, you know, the marriage wasn't doing well, and therefore he didn't owe him that duty. However, whether or not the marriage is doing well, it doesn't matter. He still owed her a special duty, right? Something to that effect. So you want to make sure that you argue both sides. Policy. So I think we should all talk about policy. This is big with probably all of your professors. It depends on where you go to school, right? Or what your professor wants. But you're never going to go wrong talking about policy. In fact, I think it is really important because you're kind of taking yourself outside of this fact pattern, saying, why? Because these are things that your professor cares about, right? This fact pattern they labored over, they did this for something that they care about. Like, I don't care about the rule against perpetuity for property. I am not going to write a long fact pattern on it. Okay. However, I find substantive due process fascinating, right? So if I'll write a long fact pattern on it. I absolutely want you to tell me why it's fascinating, right? And so the policy is important. Pay attention to what your professor says in class. And another just extra tip, if they have any articles, law review articles they've written for, any articles that are out there about a particular issue, about what you're learning, you know, maybe look that up and read it, you know, and just see, okay, you know, what do they feel about a particular issue? Because law review articles are very policy based, you know, and so what do they feel? If you're like, I don't remember, I didn't write this down, that sort of stuff. But policy is important. A lot of times, you know, damages, why do we do this? You know, something as simple as trespass, you know, like, I know one professor, it was a big deal. You know, why is exclusive possession so important? You know, and you wouldn't have thought to talk about that necessarily, but this one professor was like, it was very important. Yeah, do not use maybe, it could go either way, or, well, the court will have to decide. Oh God, no, no, no. I don't know, the court will have to decide. Okay, you are judge, jury, you're everything on this. So, well, I don't know, the court will have to decide if this was negligence. And your professor will be like, no, you were supposed to explain whether this is negligence or not. And do not bring in material from another course or your outside life. That's another thing. How many students are like, well, in my profession as, or when I did this, you know what? Another thing is like, we are kind of in a vacuum, right, of law. We don't bring in outside knowledge. We bring in common sense, but no knowledge. Mr. Raposa?
Yeah, I would also, and this obviously depends on your professor. So if they want you to, by all means, do it. Everything that we're saying today, actually, make sure you always get your professor's preference. But I would always avoid talking in the first person on an exam. It's actually one of my pet peeves when I see it. I think this, I would avoid doing that. You know, you want to avoid talking in the first person altogether, I think.
Absolutely. It is actually a big pet peeve of mine, and it really throws me when I see that. It really throws me, because while you are giving an opinion, right, so to speak, and you are putting forth an argument, it's not really about what you think so much as I think this. It's sort of, what is this argument going to do for your client, right? And so you want to not do this in the first person unless the professor wants you to do so.
Yeah, I would agree that that's a pet peeve of mine as well. And it could go either way, or the court will have to decide is, I think, one of my biggest.
Yeah.
I think I've probably shouted at exams when that happens. Like literally, you know, my neighbors can probably hear me going, "You're supposed to decide." And that's because, you know, when you're like, well, the court will decide or a judge will decide. Well, yeah, that's the way our profession works, but that's not why you're taking this exam. And Tanya said, don't bring in material from another course or your real life. Keep in mind what is being tested. Like, if you're being tested on negligence, you're not being tested on the underlying fact pattern, right? You're being tested on negligence. And so maybe you have a medical degree. There's not an expectation that you're a medical expert for purposes of this exam. So just kind of set that aside and focus on the facts given to you in the exam.
Yeah, absolutely. One of the deans at our law schools, he's a doctor and he has his master's of public health and he's a lawyer. And I'm always curious. He's very quiet too. I just want to be like, what goes through your mind when you think about anything? Because I was like, oh my God. Oh, you didn't think you were going to leave without us actually going through an exam question, right? I just want to make sure, because why would we just talk at you when we can sort of go through this together? All right, so are we ready? All right. Oops, do we have an exam problem? Sample essay? Or are we just kind of going through an answer?
Yeah, it was the intention is to just kind of show a little bit more of a meaty answer,
Oh, sorry about that.
and
Okay,
how
got
it
it, got
can
it,
be
got it.
set up.
Okay, no, we're
Yeah.
not going through an actual fact pattern together, but we're going to go through a common type of fact pattern where you would set up the answer. Sorry about that.
That's okay.
Same thing though. All right, Professor Raposa, let's talk about this meaty answer.
Yeah, so this is just an example of kind of everything we've been talking about, and it's just a fuller type of issue where we can see headings, issue statements, and analysis and conclusions and how there are different things. So this is a torts essay, and it was asking whether there's or entities can be subject to strict liability, and the student separated strict liability against the library and then strict liability against the supermarket. Um, and there's nice rule statements here written from general to specific and so forth. And so this is just another good example of a rule statement. Strict products liability is available when one sells any product in a defective condition, unreasonably dangerous to the user or consumer. A strict products liability action is only available against commercial sellers. A commercial seller is a person engaged in the business of selling products for use or consumption. So generally, I have the definition of strict liability. I get more specific, and it's defined for me that it only applies to commercial sellers. And then the rule gets more specific by defining what a commercial seller is. So, a really good example, again, of the rule statement writing that we discussed. And then you'll notice in the analysis that again it's always interweaving law and fact together. So here the chicken salad sandwich that Paul consumed was unreasonably dangerous to a consumer because it contains salmonella bacteria. So the student's just not telling me what was going on with the chicken salad, right? And then trying to conclude later, why is it significant that the chicken salad contains salmonella bacteria? It's because that makes it unreasonably dangerous to a consumer, which is an element of strict products liability. Um, However, the library is not a commercial seller. The library is not a commercial seller because it is not in the business of selling chicken salad or any other food like a restaurant would be, right? So, why is it important that we're dealing with a library in the first place in the fact pattern? It's because it demonstrates that they're not a commercial seller and therefore they're not going to be liable in strict liability. So, notice all the because statements, notice all of the interweaving of law and fact. It's a really strong analysis. And so something this example does not do, right, is mix a bunch of issues together. It also needs to talk about strict liability for the supermarket, but it does so in a completely separate way, right? A separate heading, it's a different issue. It interjects a similar rule, but a different party. So it's very neat and organized for me. And so the same thing happens here, right? As noted above, strict products liability applies to all commercial sellers. And so we're getting a little bit more into the rule of a commercial seller. So even if a retailer who has no control over the design and manufacture of a product may be found strictly liable if that retailer sells a defective product. A product is defective when it is unreasonably dangerous. Um, and then a product may be defective because it contains a manufacturing defect, because it's a design defect, or because it proves inadequate instructions or warnings. So I put here kind of a question, right? We can guess what goes in the rule next. How do we make that rule more specific? It gets more specific by um, then now defining what those different types of things are, right? What is a design defect? What is a manufacturing defect? What is failure to warn? And so
I highlighted the
this
because.
slide,
Sorry about that. This is the rule statement.
that's
So these
okay.
because should not be highlighted. I'll take them
That's
out.
okay.
I got too excited.
That's okay. And then this slide I liked because these are actual student responses that I pulled who answered this essay, and they're two different analyses. So two different students. So we have student here, supermarket is a commercial seller because it is in the business of selling food products like chicken. However, Paul would not be able to show that the chicken was defective. There is no failure to warn because the chicken sold by supermarket carried warnings of the risk of salmonella contamination and instructions on how to cook the chicken to ensure that it was safe for eating. Further, the chicken did not contain a manufacturing or design defect because the risk of salmonella contamination is inherent in raw chicken and cannot be eliminated. Therefore, the chicken conformed to the producer's specifications, and those specifications could not be altered. So therefore, the chicken was not defective. So that's student one. Then when we contrast that with student two, we've got something different. Supermarket sells chicken regularly. The chicken contained warnings of the risk of salmonella contamination, and it also contained instructions on how to cook the chicken to ensure that it was safe for eating. Nothing in the fact pattern indicates that something was wrong with the chicken, and instead, it's how you cook the chicken that creates the risk of salmonella. Therefore, supermarket will not be liable. So we can see the difference between the two students, and one large one is there's no because statement in the second student, right? So there's not a lot of interweaving law and fact together. And as a result, too, because they didn't pull out the law and connect it with the facts, the student in the second example is actually not hitting all of the elements of strict liability because they didn't kind of take the rule, bring it down, and then connect it with their relevant fact. The student instead is just kind of analyzing it without using rule and without making those connections. So it's not only not interweaving law and fact together, and we don't have a strong analysis or analysis at all in certain situations, but we're also missing important parts to discuss.
Yeah, this is a great illustration, Professor Raposa, because you can see just how her student who uses these three becauses makes this such a drastically different answer from this student right here, who you look at it, you're like, yeah, there's really no real analysis here. But the question is, how does one make it into a good analysis? And so this really illustrates to you, how this person is connecting their law and their fact together, where this person, one of the things that it stands out as is there's no connectors, right? There's no the plus, right? The law plus the fact, the law, and then that statement because, and then the fact.
Can I point out that I love this as an example, and I'd like to point out that the second answer is what I would call like a stealthy bad answer, because when the student is putting in things like nothing in the fact pattern indicates that something is wrong with the chicken, that seems really important. That seems like, oh yeah, they're on the right track, but they're not telling me why that's important. Right? Where is the because, as both Professor Shah and Professor Raposa have pointed out, nothing in the fact pattern indicates that something was wrong with the chicken. Instead, it's how you cook the chicken. Okay, well, I could potentially be fooled into thinking that was a really important thought out statement. But then I take a second look and I'm like, oh, it's not really telling me much of anything.
Yeah. Absolutely. I'm really rethinking having chicken for lunch today. Hi, Finn. Hi. Oh my goodness. Finn is our beloved pup project manager for our LawTutors.
He climbed up here.
He climbed up here. He wants to manage this thing.
Wants to be part of this webinar.
I know. Hi, sweetheart.
Meanwhile, the cat employees are still napping.
Oh,
so
yeah.
I think it says a lot about their work ethic.
Office catechit is Iggy. And I forgot what Lemmy is. Lemmy's coming up.
He's hiding under a blanket, and I think that says a lot about his work ethic.
Oh, Lemmy's IT, because he likes to be on your computer. On our site and our Instagrams, we have our pets of LawTutors every Saturday, by the way, on our Instagram. And all of our pets they pretty much run this company. We're more like their employees, but we've got our little pets of LawTutors all the time. We love all of our LawTutors pets. All right. We're to get practicing. Now I know we brought this up sort of in the beginning. So first and foremost, old and past exams from your professor, hypotheticals from your casebook, hypotheticals from class, and studies. Now, one of the things about old and past exams from your professors is also what you do with it. Reading an exam and reading an answer is not the active way to use your professor's past exams, okay? let's say that, first of all, figure out how many there are, right? And plan out when to do them. If you're really like, I have no idea what they're looking for, and I've told this to my students before, you can do a practice exam, because you don't want to waste, these exams, depending on how many there are, right? But if they have a sample answer, rubric, checklist, you actively use that to create your own checklist, pre-writing, whatever it is you do. We don't just, okay, I read it, I get it, right? Because so many, we're like, oh yeah, they make it sound so simple. Okay, yeah, I'll just do that. No. My sister makes science sound simple to me, but I can't just go do it, okay? Because things would explode. So this, and I've talked to some of you already about this, like use that sample answer, like that is gold, right? Or even if not a sample answer, even if it's just a memo about, some of your professors are like, this is how I wanted you to address this, or here's just a checklist of things, or whatever it is that is there, that is, use that. If you don't have one of those things, that's fine, okay? Use that exam as an example of how they are testing you, and use your own notes and see, what, does my outline, chart, checklist, whatever, guide me or help me in my practice exam? If it doesn't, it's time to tweak that, right? So does all your equipment, help you with this exam? And if you're like, okay, my stuff is useless, then it's time to tweak that in a way to make it useful for you.
And one main reason to not just look at a sample answer, like Professor Shaw said, she's like, reading isn't the same, and it's not. And one of the main reasons it's not the same is I have students who will go through and maybe write, for example, the torts that they see, or they'll write what they think are the correct conclusions. And then they'll compare that with a sample answer or a checklist and say, well, I got all the right issues, so that's enough. And it's not enough, because if you notice this whole presentation, like the examples that Professor Raposa gave you, it's not about, oh, these students got different issues or they had different conclusions. It's how they explained themselves. So don't fall into the trap of looking at a sample answer and going, this looks like what I just did, because you have the same issues. It's how you present those issues, and that takes practice.
Yeah. And we can't reiterate enough the hypotheticals from your case book and from class, right? Make sure that those are going in, your outline, those hypotheticals from class. And like we said, any study aids, examples and explanations is fantastic. Like I said, Study Buddy Pro, which is online, you can register for that. Ask, your library, especially because of COVID. There is a lot of different things that they have that they can send you an email to you for study aids, for practice. For some reason, by the way, I had a dream about examples and explanations last night. I have no idea why. That tells you about my life, but I had a dream about it. Professor Rose, did you have anything to add on study aids or anything? No. Yeah. All right. So we'd be remiss if we didn't talk about multiple choice questions. And those of you who have me in class know that we actually just did a lecture on multiple choice questions this past Monday. And one of the things I want to say about multiple choice questions is they're not just for multiple choice. They're a great way of understanding IRAC as well. Of understanding, spotting an issue, knowing the rule, applying it to the fact patterns, and coming to a conclusion, which is the answer choice, right? So some of your professors may have multiple choice questions. So there are ways to read it. There are things that you cannot skip, like you have to know the law, right? But there are ways, when some people say to me, I'm just so bad at multiple choice exams, like, let's figure out what that issue is, right? The first thing we always do is read the call of the question. It may direct us, especially if it's like, did Joe commit a battery? Then we're like, okay, it's going to be intentional towards battery. Then we're going to read the fact pattern actively. You know, let's pick out keywords. All those things, all the things that we talked about that would help you issue spot on an essay exam are the same ways you are going to issue spot on multiple choice. There's no difference, right? Pick out the specific legal issue from the fact pattern. Don't be jumping to the answer choices, right? And being like, maybe I can find it in here. Okay, no. You'll find it in one of the answer choices, but you might not know which one that is, and the other three, you're not going to find it. So apply the law to the facts, and then choose the best answer choice that matches your answer. And as a note, and this is sort of that repetition of the facts things, and this is where it comes into play in multiple choice, and a lot of the times these multiple choice writers know it. Sometimes students will pick a correct statement, but it's a correct statement of fact, right? And they're like, this looks great. Well, it looks great because it was in the fact pattern, right? And so and this is not an all or nothing thing, but mostly what you're actually looking for is a correct statement of law that connects to the facts, right? And not necessarily just a restatement of the facts. Now, it depends on what the question's asking. If it says, what additional facts would help us resolve this, then yes, you pick something with additional facts. There's so many things we can say about multiple choice. So Professor Raposa and Professor Harrell, I'll let you add some of your insights as well. Unless I already gave away all the insights.
Just don't pick answers because you think, like, one of the most common things I see students do is like, well, I pick C because I have no idea what that is.
Yes.
Why would you do that? Why? So don't, because what happens is you're taking the exam and you start doubting all of your knowledge.
You doubt
and
your
you're like,
existence.
C brought up a legal concept I've never heard of. That must be correct. Yes. It probably isn't. And, you know, Professor Shaw has given you a great methodical way to go through multiple choice. Don't lose sight of that. I think people screw up multiple choice because of time constraints, and they kind of panic. If you stick to the methodology and really thinking it through, you're going to be fine.
Yeah. Some things really sound good. And one thing I always ask my students, like, I'm sorry, have we ever, it sounds really great, you know, but I'm like, but have we ever addressed anything that sounds like that in the rule of battery? Like, you know, or have we ever addressed anything like that? Because it can sound logically wonderful, and you're like, oh, that's how life should be. But I'm like, but is that, have we ever, so if you've never discussed it in class, in a hypo, in a case, probably not the right answer. Professor Raposa?
Yeah, I would just say well, one, if you don't have multiple choice questions on your exam, I still think they can be helpful to practice here and there, because I think they can let you know if you understand the law. So it's almost just like a test to see if you know the law and understand it. If you do have multiple choice questions on your exam, just make sure that you do practice some again before your final. You likely will spend, depending upon the multiple choice question, about 2 minutes per question. But sometimes maybe it's a really lengthy question and your professor intends for you to spend longer on it. So just make sure you allocate your time to multiple choice question versus any essays that you might have on the exam.
Absolutely. So this was great. Professor Raposa is very, very cognizant and has spent a lot of time kind of thinking about the actual experience of taking an exam online. And in fact, when we were, you know, as many of you may know or have heard, you know, the bar exam was administered online in many states for the first time in October. And Professor Raposa put together a very, very thoughtful, you know, panel and of what it would be like to take this exam online. And we had an overwhelming number of participants, mainly because there was so much anxiety like, how do you take a bar exam online, right? And so it's not lost on us that that same anxiety is there for you when you take an exam online. Because I'll let you talk about this, because I know you spent a lot of time thinking about this, talking with tons of your colleagues and coming up with methodologies and stuff like that.
Yeah, so this is just for all of you who are taking exams remotely online due to the pandemic, or maybe you're in online classes. And just some tips to find a quiet space, make sure it has internet connection, notify everyone who might bother you that day that you have a final exam and what time that exam is. I suggest getting comfortable with that space that you're going to take your exam in, study there, do practice questions there, so you have a level of comfortability with the space. Make it your own, make it your safe space. You're going to take this exam there, you're comfortable with it. And then if you are having trouble with your internet connection, you don't have a quiet and safe space at home. Not everyone has the same privileges, and not everyone has the same resources. Make sure you contact your school, and indicate that you might need assistance, because your law school likely can give you a space to take the exam at school. And so definitely don't be afraid to do that.
Yeah, absolutely. I know one of my students has all of their kids homeschooling at the same time, all 8. And they're all homeschooling, and she's doing law school. And it's like, I don't care how fast your internet connection is, that is the bandwidth stretching, you know? And so, you always want to be actively asking people, your school, for help, things like that, saying, listen, you know what? I'm not going to have a reliable connection. I'm not going to have this. I'm not going to, be able to do this. And what can you do for me? Is there a place I can study? Is there a place I can do this? Is there a place I can do that? But shout out to that student, by the way. I'm not going to say who she is, but I'm always like, oh my goodness, like, that is amazing. She knows she knows that I think she's a superpower. All right.
Before questions, can I add one more tip?
Yes, please.
That we kind of forgot about, not intentionally, but the only reason I haven't forgotten about this is because I met with a student yesterday who really did poorly on their midterm. And we were going through it, and he had missed many issues. Like, let's say there were 6 issues in the midterm. I think he failed to bring up 3 or 4 of them. And I said, well, let's talk about why you didn't recognize those issues, what was happening. And he's like, well, I knew they were claims, but I didn't think the claims would be successful, so I didn't bring it up. Meaning he recognized that there was a potential battery, for example, but he also recognized that one of the elements would not be able to be proven. So he just ignored it and didn't get any points. What your professors want you to do is bring up a potential claim to knock it down if that's the case. So don't already prejudge a claim and say, oh, well, Bob isn't going to be successful on the battery claim, so I'm not going to talk about it. Your professor probably wants you to say, Bob will sue whoever for battery. Here's how I define battery, and here's why this particular instance is not a battery. And a lot of students make that mistake. They find out after their final that they could have gotten many more points had they brought up the issues they saw, but dismissed because they didn't think that they could be proven.
That's such a great point. And that's why I think that example that Professor Raposa gave was really, really important about showing that something is not but for cause, right? Because that's just as important as showing that something is but for cause, And so thinking like, well, I didn't think it was an issue. Like, your professor doesn't know that you know that it doesn't meet but for cause unless you explain it to your professor, right? Or else they might just think that you didn't spot it. And before we go into questions, because I wasn't able to post this link, I'm gonna just take you. Sorry, take to our. I know you can see my screen, but where you can not only sign up for some of our webinars, but if my internet decides to work, so if you go to law students, there's actual listed as free webinars, okay? So, oops, that's not where it's listed. Hold on. Free webinars. Let's go to free webinars.
I posted this link in the chat.
Oh, you did? Okay. Oh, there we go. So it's in the chat, and so there's free webinars. Now, if you've missed any of these, you can go to our YouTube channel as well. But we have more for next semester. You got your first semester grades. Now what? I think that's the big one, you know, practicing for exams, pre-writing for exams, stuff like that. Also on our YouTube channel, you'll be able to find the videos from before. And then I'll just take you really quickly to Study Buddy Pro, if I can spell it. There we go. And what we were talking about in there, and then how you kind of want to go. You would go to start my free 7-day trial, and then you'll get sort of access to everything. And you're just going to want to cancel beforehand. All right, let me stop sharing. And questions.
There was one question that we didn't answer.
Oh.
And it was, it's about word limits on exams, and I think some advice for that when you have a word limit.
I think I answered that in the chat.
Oh, okay.
Oh no, I didn't. I'm sorry. I apologize.
I would say, I'm going to let Tanya take over on that one, but I would say this goes back to organization. Start your outline, determine what's important, and then if you have to make cuts, you have to make cuts. But if you start organizing and kind of weigh your issues, that's going to help you with that word limit.
Right. Absolutely. Yeah. This is a big help. I'm also, oh, thank you so much, Melena. Nice to see you. All right, good. Any other questions, concerns? Well, thank you for spending this Saturday, this big news Saturday, with us. And big news because, you know, it's our webinar. Please, we're going to email you your recording, right? So you don't have to wait until it's posted on YouTube. So we'll email you the recording, and I'll make sure you should be getting an email from Liza, who is our office manager. And this will also be posted on YouTube, but in there you'll also see all of the slides and everything. And you can also email us at info@lawtutors.net, and or you might have my email address. Some of you do. Thanks for all of you for attending live. I know that a lot of times, you know, we're like, okay, well, it's recorded, so I'm going to watch it later, and especially on a day of such big news today. And so you're welcome, and I'm so excited to see some of our students here. We love you guys, and this was great. I mean, we had a lot of fun, and so I really want you to take this information and remember to use it for your benefit. I want you to be relieved, hopefully, after this, not more anxious, and say, okay, I have these great tools and these great skills. And I am just going to say one more thing, not to be very woo-woo on you. No, those of you who have me as a professor know I do this, so I'm going to do it again. Some of you may have gotten midterms and we're not super happy, or even if you were happy, you want to keep that going. Some of you might feel anxious and stuff like that. And just remember that these are all learnable skills. You don't come in with a fixed mindset of I can do this and I can't do this, right? I'm not smart, that person's smart, right? These are learnable, and maybe you don't feel like you can master them. But remember, maybe you didn't master them yet, but that doesn't mean that you're not going to. And so we really want you to think, and I know Professor Hale and Professor Proposa is big on this, and actually Professor Hale was really big about adding this to one of the books that we're writing, is this growth mindset concept that you might go into law school, your master's law program, and be like, oh gosh, you know, I don't have any person in my family that's a lawyer, or that person seems so much smarter, that person. No, okay? This is all about where you can go from here, and knowing that it doesn't matter if you're there yet, you will get there. And Professor Hale, I don't know if you want to add anything, because I pretty much stole that from the fact that she added that to one of the books that we're writing.
I would just say Tanya said yet, and that's in the research I've done on growth mindset. The single best way to expand your growth mindset is to add yet. You haven't mastered IRAC yet. You haven't mastered contracts yet. It doesn't mean you won't. And I know all of you guys are adults, so think back to something, a skill you might have learned as a kid, as cheesy as it is, riding a bike. For me, it was playing piano. You don't sit down at the piano the very first time and like are a genius, you know what I mean? It takes work, it takes practice, and build that little by little. Exams are the same way.
Yeah, and I gave some of you guys some examples of, just because you might have quote unquote innate genius or natural talent does not mean that leads to success. What leads to success, what the research shows, you can have a fixed mindset and be innately smart. What leads to success is that growth mindset and that power of yet and that resiliency, right? How many students of mine was like, I got my midterm back, I cried, I ate ice cream. You know, you want to do that for a day? No problem. But after that, you look at that as another big thing. We look at it as a neutral circumstance, because what you can do is you can change how you think about something. You can look at a midterm that you didn't do as well as you wanted to do on and think, this is terrible, I will never learn how to write. And that's gonna lead into your actions. Or you can look at that midterm and say, that thing that happened, that midterm, is a neutral circumstance. So you decide how you want to think about it. So if you can look at a midterm or you're there and say, okay, I didn't do all that in medicine, so I haven't learned how to write like a law student yet. However, I am now going to learn how to do it. Right? So that's another thing. You know, we can't think the way that you think. We can't change the way that you think overnight. But we can tell you a couple of things to aid you in making sure that your mindset sort of aligns with how you're practicing for this, because we don't want you to practice out of fear. I mean, fear is a great catalyst. It's just not a very pleasant one, right? So we don't want you to practice out of fear or out of fear. I want you to do this because you're like, yeah, I'm badass and I can do this. Sorry about swearing. Professor Raposa, and those students who know this know that I did my job talk on this, and I said to a bunch of professors, I'm like, listen, this is what we're meeting, and they're like, missing from our curriculum. And they're like, I'm sorry, what is this? And so, you know, but I do firmly believe in this. I know Professor Hale does, because she's done a lot of research on this, and Professor Raposa is a constant cheerleader for her students and always thinking about her students' mindsets and mental health and things like that. Do either of you have anything to add? All right. Well, thanks for joining us. You know, I had fun. I don't know what I'd rather be doing on a Saturday. But again, we'll have this, and we'll chat with you. Hopefully we'll see you at some more webinars. Hopefully that, you know, you'll come back the second semester and be like, I did so awesomely. I just want to come back and do some more. So we'll talk to you all soon. See you all soon if I see you in class, or hope to chat with you. For those of you who I haven't met, please feel free to email us. Bye, everyone. Have a good Saturday.